Good afternoon. So today, the Sub-Appropriations Committee on the State and Local Transportation Budget will come to order, and will the clerk please call the roll for today's attendance?
Thank you, Madam Chair. Representative Steele.
Here.
Representative Slaw.
Present.
Representative Borton. Representative DeCina. Representative Robinson.
Present.
Representative Morgan.
Present.
Representative Edwards. Madam Chair, you have 4 of 7 members. You have a quorum.
I'm sure they'll show up. So, okay, let's see. Let me see. Representative Slaw moves to adopt the minutes of the June 4th meeting. Being no objections, the motion prevails by unanimous consent. Okay, moving right along. So today, I really appreciate you guys coming out today to testify and be a part of this committee meeting. So I just want to let you know that our hearing goes until 1:30, and I know somebody has to leave early, and I know somebody's coming in late, but I'm trying to make a hard stop by 15 after so we can make it to the Capitol on time for next session. So today's committee was called to discuss about outdoor advertising, also known as billboards. So to start off is Max Albrecht from the Michigan Department of Transportation. He's the legislative liaison, and with him is Larry Doyle. Raise your hand, Larry. Thanks, Larry. He's from the Development Services Division Administrator, along with Melissa Staffeld, Highway Advertising Specialist, and is there a D. Parker? There you, yes, right, I recognize you from last time. Bureau of Development and Director, and you guys are all from MDOT?
Correct.
Okay, so I appreciate that. So I'm learning here every single day, so you have to bear with me. Next year, I'll be a lot smarter and brighter and better. So I think just to piggyback from our last meeting, which was discussing Section 107 of the budget, and I think it's how much money? $280 million. Let's see, $215 million. And in our budget, it's 3 lines, but I know billboards, AKA advertising, is in that portion of 107. And so just in the process of learning and understanding our budget better, we're just trying to break down certain segments, and billboards and the outside advertising is part of that. And so with that introduction, if you guys are ready, just start whenever you're ready.
Okay. All right. Thank you. Yeah, so I'll just start off. Melissa's going to start off with the first couple of slides. You know, billboards are very complicated, very litigious. So we try to provide an overview of all the different issues, and starting off with the history of the billboard regulations that happen, both federally and state. It's MDOT's role to enforce those regulations. So Melissa is our statewide specialist, and that's what she does every day, every week, every year. So I'll turn it over to Melissa. Yeah.
Thank you. So I have been in this position as highway advertising specialist for 19 years, and I still learn. It's always a learning process. There's always a learning curve. So some history, the Highway Beautification Act, the federal statute, was enacted in 1965. Lady Bird Johnson wanted the roadways to not be cluttered with billboards and junkyards. So the Highway Beautification Act was enacted. It did put a 10% penalty of federal highway funds if other states did not have a highway advertising program to effectively control billboards along their highways. So that came a federal-state agreement. For Michigan, it was in 1972, which mimicked the federal regulations that were in effect. So regulated the size, lighting, and spacing of billboards. So we only regulate off-premises signs, which we refer to as billboards. So any sign that doesn't advertise a business or activity on the premises. Any on-premises signs, we do not regulate. So out of the 50 states, 46 states have billboard regulations, federal state agreements. 4 states completely prohibit those billboards, which are Maine, Vermont Highway, and Alaska. So in Michigan, there's 11,700 miles that are regulated, which includes M routes, US routes, interstates, and freeways. In 2012, the Moving Ahead for Progress in the 21st Century was passed by Congress, which added to Michigan's miles 1,677. We have 14,435 commercial sign permits. And the way Michigan permits is we permit by face, not by location. So if a location has two sides to that structure, each each display requires a permit. And then out of those 14,000, we have 582 digital permits that are active in the state. And again, we don't regulate on-premises signs, so an on-premises sign would be advertising a business at that location or an activity at that location, so that falls under local regulations. So the major amendments to the Highway Advertising Act, the last major amendments were in 2006 under the Public Act 447, which introduced the cap and trade system. So what that entailed is it put a cap on the number of billboards in the state at that time. And companies or individuals who held permits had a year to either construct a sign or if they had a permit, or surrender those permits to get what are called interim permits if they didn't construct. So an interim permit is one that is not associated with any location, but it does allow the permit holder to use that permit to apply for a different legal location to construct a sign. So if you don't hold an interim permit and you want to put up a sign, you couldn't just come in and apply. You have to hold this interim permit in order to do that. Currently, if you have a sign that you think is not generating enough income and you want a different location, you can remove that sign and the sign structure and exchange the permits to receive the interim permits. And it's a one-for-one count, but no more than 2 interim permits. So for instance, if you had a 4-panel sign at a location, the maximum you could receive under law is 2 interim permits. The interim permits are valuable. I always have people contacting me wanting to put up billboards. I explain the process. They want to purchase permits. So I provide them a list of existing permit holders, and it's up to them to find someone who will sell them their permit. And that, again, is the only way one can apply to construct a sign is with that interim permit. So they are very valuable. If I have a customer contact me who just has a couple permits, and says, I don't need the sign anymore, I just want to cancel the permits, I do explain that they are valuable. You might want to go through this process and try to sell them. And they are the ones that place the price on those permits if they choose to sell them. So in Michigan, there are 1,305 active interim permits. So those interim permits are available to use to construct new signs. So just a few of the regulations, high level, spacing along our highways. We have 1,000 feet spacing between billboards on freeways and interstate, 500 feet spacing between signs on non-freeway, and that's along the same side of the road. If you have a digital display, you must have 1,750 feet spacing between digitals that are facing the same direction of oncoming traffic, and that is on either side of the highway. You must have landowner permission. These signs are located on private property that are visible from our highways. They are not located in our right-of-way. So they must have landowner permission. The zoning must be considered a business area, and that business area is zoned commercial or industrial or some similar classification. If the property is unzoned, then they must have a commercial or industrial business within 800 feet, and that must also be on the same side of the highway. Also, under the amendments back in 2007, 2014, No new billboards can be erected where there's mature vegetation within the right-of-way that MDOT intends to maintain. So just a few figures on our permit applications that come in. Just in last year, we had a total of 240 applications, and that was among digital and statics. We had 90 locations approved, 82 issued, and 68 denied. So how this process works is once we receive an application and determine that it meets regulations, the location is approved, the customer has 1 year to construct that sign. If that sign is not constructed within 1 year, then that application or that location approval expires. So a lot of those denials were based on the fact that the company, for whatever reason, could not construct that sign within the 1 year. The location approval expired. There are other reasons. It could be due to zoning or vegetation located in our right-of-way where we couldn't approve. But the majority usually comes to the company just wasn't able to put it up, and then they can reapply. As of this year, we are low on incoming applications, but that will also pick up. We've only had 38, 24 approved, 8 issued, and then 7 denied. Our permit application fees, these have been the same since 1998, excluding the digital fee. The digital permit fee went into effect in 2014 through amendments. So we have $100 for static, $300 for the digital, and then if a company wants to convert their existing sign to a digital, then they can pay the $200 application fee for that. I've listed the fees that MDOT has brought in over to 2024 and 2025 for the digitals and the statics, 47,100 in 24 and 8,000 so far in 25. Our permit renewal fees, again, these are statutory as well. These were last increased in 2007 through amendments. They were once $40 and $80 based on size, and now they're, $40 and $25, and now they're $50 and $80. And again, those are based on the size of the face. We do assess a late fee if permits are not paid by the renewal date or their expiration date. And then there's also a $200 digital fee. 2024, we were just over $1 million. And then as of now, we're at 759. The fees that we bring in, there is no line item for outdoor advertising. All the fees go to the state transportation fund.
All right, so I'm going to talk a little bit about billboard vegetation management permit. So this is just a graphic. This came from Scenic Michigan, just showing the number of states. The ones in yellow do allow vegetation management within the right-of-way. The reason for vegetation management, the billboards are located outside the right-of-way. A lot of times the billboard owner will work with the property owner if there's any trees or anything impeding the view of the billboard. But the billboard company has to come to MDOT if there's vegetation within our right-of-way that's impeding the view of that. So, and that's where a permit is required for that vegetation management. So basically the process is they apply for a survey, they define the billboard viewing zone. We do require an arborist to go out and mark the trees, evaluate the trees. And then they'll propose a list of alternatives of which trees they want to trim or cut, and then they'll either offer mitigation or we will look at the value of that vegetation if we're willing to have it removed within our right-of-way. So, similar to what Melissa talked about, so here are some of the numbers for applications and the fees. So. January of 2024 through almost year to date, we had 316 applications received for vegetation management. We issued 255. The fee structure for the application fee is $150, and then it's also If the application is approved, then there's a $500 permit fee. And then plus, like I mentioned, for the appraised value of removed vegetation, that also gets assessed. So in 2024, we had 150 permits issued. We had almost 148,000 of fees and revenue. 2025, year to date, we had 105 permits issued and almost 113,000 with fees. So that was basically a high level. We didn't want to go too in depth. I know you guys probably have questions, so we wanted to leave a lot of time for that. So.
Thank you for your presentation, and I think that, I have a question, I don't know if anybody else does, Andrew's gonna write them down, but I guess, so you have, sounds confusing, but.
It is
I
confusing.
forget that we're at the state, so, okay, so I'm, a sign owner.
Yeah.
But I don't own the land, MDOT does?
No, it's private property.
Private property, but I have to go get a permit from MDOT even though it's private property?
Because it's visible from
Okay, and
MDOT's
then.
highways.
And then with the permit, then I have to, if I want to cut a tree, I have to go back to MDOT to cut a tree? Or have MDOT cut the tree on my behalf and then pay for that tree cutting?
Yeah, you have to come to, if the tree is in MDOT's property, then yeah, you have to come to MDOT and ask permission to cut that tree within our property.
If it's in your property, but not if it's a private land, so.
Right,
if
if it's on the where the billboard is located and that's a private, then the billboard, I assume, they work directly with the landowner on the vegetation on their side. I'll say their side of the fence versus our side of the fence, which we manage, the roadway.
So if I'm a sign owner, leaser from a lessor, and I have to get a permit to put the sign there, and then it's a tree in MDOT, I have to get a permit to ask MDOT to remove a tree in the right-of-way, and then I can move it, or you guys can move it? And then do I have to pay for a tree too, and for,
Yeah, that's what, when they apply for a vegetation permit removal, we have them utilize an arborist to do an inventory of the trees, what their condition is, and then if they're telling us which ones they want to trim versus which ones they want to remove, a lot of times they'll say, I'm willing to plant trees over here to make up for the trees. And then we take all that information and evaluate whether or not we will approve that vegetation permit for it.
so I have an arborist and an appraiser doing this to go out
The
there?
arborist they do both. Yeah.
So,
Yeah.
do you have a contracted arborist, or do you have one in-house?
We require the sign
pay for
owner
their-
to pay
for
for
an
the
arborist.
arborist. We have what we call resource specialists in each one of our 7 regions that work on a variety of things. Vegetation is one of them. They also work on, all the other environmental types of things, whether it's permitting or things like that. But they evaluate, they review, they go out and look at that vegetation. They look to see if MDOT planted that vegetation with federal funds. They look at the aesthetic value of that vegetation. Is it providing other ancillary benefits for drainage or, erosion control? Helping with snow block, just a lot of different things that go into it, whether we want to allow for these trees or vegetation be removed in our right-of-way.
So if I want to remove a tree, I have to go through all that?
Yes.
Seems
Yeah, I give the
a lot.
analogy, it's like, your neighbor has this tree and it's impeding your view of a lake, and you want to have them remove that tree, you need their permission to do it.
So how is that service? How is that service through MDOT? I mean, is it easy to do all that? Is it inexpensive? Is it tough to get an arborist out there? Is it tough to get an appraisal? I mean, being that a sign owner has to pay all those fees and go through all that steps, is it easy to work with the state? How many people
Yeah,
do
I
you
mean, I'll
have?
just go through, so in 2024, we had 316 applications. We approved 255. This is through January of 2024 through 2025. So majority of the applications were approved. Hundreds of applications were processed. I'm not gonna, you can ask the Billboard if they think it's easy, you know, it is a process, it is set in statute. We can only deny vegetation removal based on certain conditions that are within statute.
And then we said earlier that you didn't have a line item for this, so do these permits pay for that portion of the department in section 107, that, do the fees offset that? Or
So a
is
lot
there-
of our times, and Bill can help me more than, right? Anytime, like, something that goes through, we call it, go through formula, it goes basically up to the thing, and it'll trickle down, right? It's part of the Michigan, you know, the MTF, the Michigan Transportation Fund, and it'll be broken out, but it does not go specifically into our area within our section of MDOT.
So we don't know if the fees are covering the management of it, or if there's an excess of fees that, for the management of it. We
Yeah,
don't know that.
I mean, we have looked at our fee structure. We get audited regularly. In fact, we're just finishing up an audit with OAG, a preliminary interview with them. They did look at the things, so they will be reporting on that. But we do look at our fee structure. In statute, there is we have the ability to increase fees based on, for certain aspects of fees for vegetation to make sure we're covering our costs. We have not done that. Melissa pointed out some of these fees have not been increased for, you know.
And then how many people in that portion of the department?
So Melissa, I mean, she, like I mentioned earlier, she's, you know, she does all the processing of Billboard permits, but she utilizes staff for inventory. We're utilizing consultant to help with inventory to make sure that have effective control per federal highways requirements. And then we have our 7 regions that have personnel. I mentioned the resource specialist is one of them, that each region, so if there's a billboard up in the UP, Melissa isn't the one driving up there, it's someone in the UP office,
Okay.
you know, that
In the
will
region, okay.
go out and look at. That's why we require that survey. So they go out and mark the trees they want to remove. The arborist will provide a report with the condition of the trees, the value of the trees, and any mitigation. And then that person in the region office will make that determination and send it back to our, you know, central office staff for processing of those permits.
Okay, and Representative Slaw, you had a question?
Yeah, I'm not sure how articulate this is going to be as it comes out, but, so help me understand how you obtain an appraisal value of the vegetation that you're going to remove out of your area.
Yeah, so in statute, it actually kind of tries to define that, and I forget there's a arborist, I don't have it in front of me, but there's basically a book of appraisal techniques and values for types of vegetation, so.
And then is it a percentage of that value that you're charging as a fee, or is it a flat fee based on a certain number of dollars, or
Yeah,
how does that fee get calculated?
Yeah, so the application fee, just for us to consider, is a $150 flat fee, so. And then once we get the arborist report and our region resource specialist reviews it and say, we're willing to go with that proposal or whatever the compromise was, then it's a $500 permit fee. And then if there is, you know, say there's 20, you know, really nice, I don't know, you know, my tree values, but, you know, a tree that's more valuable than others, we may assess and say, well, these trees are very valuable, so in addition to that 500, there is the assessed value of that vegetation that you're going to remove, so.
Did I hear you say that though you're charging me, that there might be a way to offset those fees by planting something someplace else, or is that, did I hear that correctly?
Yeah, that is correct. And it's in statute that they may offer as part of their application, you know, what their proposal is and different alternatives. It may be, I want to take out these 6 trees, I'm willing to plant 4 more over here, or I'm willing, you know, a lot of times they'll say, you know, the value of these trees is minimal, we don't think there is a value, so we're not offering, you know, mitigation, so. Yeah.
I'll talk to everybody, not just
Yeah.
Representative Slaw. So I think that we're going to have a testimony from the association, so I might answer some other questions. And I'm hoping, thank you for your testimony, and I'm hoping, too many things at one time. So, okay, so I'm hoping that you guys can stay through their testimony.
Absolutely.
And if we have further questions, that you can step back up and maybe answer on the behalf of MDOT. But before, Rep. Robinson has a question. Hold on a second, Rep. And then we have a point of clarification from our fiscal, Bill Hamilton. So let's start with Bill, and then we'll follow up with you.
Just two quick things. So as you mentioned, the total permit fee revenue each year is about $1 million, and it's pretty consistent year after year. And that's credited to the state trunk line fund, the STF.
STF, okay.
Which is the fund.
Thank you
that
for correcting me.
That supports MDOT's
Yeah.
operations. And the second quick thing, the vegetation replacement cost, that's, as you mentioned, that is defined in statute. I left members a copy of the last time the
Yeah.
Act was amended. This is back in 2013, and it describes how the vegetation cost is calculated in statute.
Yes, thank you.
So a buckthorn's not worth much, I have to say, so. Rep. Robinson?
Thank you, Madam Chair. What, if any, support is available for small business to navigate through these regulations you guys have? If any, is there any?
Yeah, I mean, Melissa can give,
Yeah. I mean, as far as the Billboard application process, I'm always there to assist in explaining the process, walking them through. We do things online, so, some individuals don't quite understand it, they try it. So I absolutely am there to assist in walking them through this and how they have to submit their application packets.
You don't happen to work with any local chambers with this, or is that something you do, or is that something that would make it easier for, because the process can be quite intimidating for small businesses, and just the application fee being $150 with no guarantee.
Yeah,
I'd
that's for
like-
vegetation.
yeah.
I'm just speaking to sign permit applications.
Yeah.
The vegetation process is through a different database, and because the vegetation is within our right-of-way, we have our permit agent, Joe Rios, who handles all the vegetation management area. So I know that they do assist customers. In fact, I just listened to him this morning, assist a customer in walking them
Yeah.
through an application process.
Yeah, we're always willing to help, but we understand the complications. When we say we know it's complicated and we've been doing this thing and trying to interpret and, clarify that, so we definitely understand that. We are willing to work with them. That was one of the reasons why these local TSC offices were placed closer. Instead of having to come to Lansing, everything, we have, people in every region, 7 regions, 20-some local offices to help with, the local customer.
You good, Rep? For now? Okay, thank you for your presentation. And we have now coming up forward is Bill Jackson with the Outdoor Advertising Association of Michigan. I know it's hard to believe that we have an association for billboards, but we do. And Bill is the person with this. He was destined for this job. So if you could come on up and then bring your guests if they are here to testify. Okay, fair enough. Start whenever you're ready. Thank you for being here.
Well, good morning, Madam Chair and members of the committee. My name is Bill Jackson. I am actually a partner with McKelvey Merchant & Associates, and I do have the unique opportunity with the association, the Outdoor Advertising Association of Michigan. They were actually my first client, and I am the contract executive director. So they are fortunate and unfortunate at the same time to, I am the only client that I will testify for. So, and a little bit of my background. So I actually come out of the industry. So I spent a decade in the industry handling real estate and government affairs for Adams Outdoor Advertising, working with the association through that period of time. And when I decided to leave the industry, you will find that you will never look at billboards again after this committee hearing. Imagine what it's like being in the industry. It kind of gets in your blood. And so I was very fortunate that they've been with us now for going on the 14 years that I've been with the firm. So it's very exciting. And yes, Representative Steele, Madam Chair, we do have an association. It is, we believe, the oldest trade association in Lansing. It was founded in 1875. We've yet to find any records that show any other association is older than us. The closest we've found is I believe it was the Hardware Association that was founded in 1895. So billboards have been around for some time. We could even say it goes back to the ancient Egyptian cuneiform if you read the history of billboards. So a little bit about the industry. We've had a lot of consolidation over the years. The association is made up of a small group of companies which manage over 10,000 of the 14,000 billboards that you saw here. We're very proud to have one of the oldest Michigan companies as part of our association. Wolverine Sign Works, located in Owasso, is a fifth-generation family-owned company that was started 110 years ago and is still a member of the association, is still in the same family. A little bit about what we do. Obviously, we provide advertising, and most of that advertising we provide to over 80% of our billboards are bought by small and local businesses. Representative Robinson, you talked about small businesses. Our companies are local. They give back to the community. Over 10% of our billboard space is given back to charity and community organizations throughout the state, and 80% of the work we do is with local businesses. It is a growing industry, a vibrant industry, and again, that part of that is you are seeing a huge fragmentation in the media marketplace. Those of you who are responsible for buying campaign advertisements know, where do we advertise these days? Who do we reach? What radio station? What satellite station? What internet? What, you know, billboards are never present in the marketplace. You know, I think Melissa Staffeld did a wonderful job, and Larry Doyle did a wonderful job kind of giving the history of the regulation a little bit. I'd like to give maybe a little bit of an industry's perspective on the regulation and the history. There's a couple of us who in the room today who have been involved in every piece of billboard legislation that's run through the legislature in the past 22 years, myself included, and Ms. Staffeld. From 1972 to 2006, we saw an act that was amended, I would say, on a minor level, on a pretty consistent basis. When things would change nationally, they may change locally. We saw some spacing changes, but for the most part, there wasn't any real major changes to the industry until 2006, Public Act 447. From an industry standpoint, that was a pretty significant change. It took us a couple years to bring everyone to the table to get that piece of legislation done. And in my career, it represented the first grand bargain. We talk about grand bargains in Lansing often. Our grand bargain that the industry put forth was, we said, we'll stop building additional billboards. Only state in the country that says we're not going to build any more billboards than what we have to this day. Now, if we take one down, we have the ability to move that around, as Ms. Staffeld said, or we can bank those permits. But we said, I want you to think about that for a minute, because it's real important when we talk about the trade-off. We said, we aren't going to grow our size. We're going to be no bigger than we are today in 2006. And I don't know any industry that's ever come to the table and has said such a thing or done such a thing. We are the only industry in the country. We took a little bit of heat of billboard industry in the country, and the only state that has a cap and replace outside of those states where we have full prohibition. Now, of course, you might be asking, why would an industry do that? Well, at that time, we had a significant number of our assets along the highways that were unsaleable. We were unable to sell them because they were covered by trees, and we didn't have a good permitting scheme, if you will, to utilize those, to get the permit to cut the trees down. At the same time, digital billboards were coming on the scene, and digital billboards were the future of outdoor advertising. And at that time, we had some ambiguities in the law as to whether or not digital billboards were even allowed. So we had a situation we were facing as an industry that trees were continuing to grow up in front of our billboards, and we were seeing fewer and fewer billboards that we could sell. And we were in a position where we were under threat that we couldn't utilize new technology. So we came to the table with all the stakeholder groups, and the grand bargain was, we'll stop growing, right? We won't get any bigger than we are today. We have no more billboards on the side of the road today than we had 2006. In fact, our companies have taken billboards down and banked those permits. So I would argue we have fewer billboards on the side of the highway than we had in 2006. And the trade-off was we would be able to protect and preserve and maximize those locations left through the use of permitting and through the use of digital billboards and through protections for just compensation through condemnation. We understand that one of the big pieces of our, as we're building new roads, we understand as an industry that we have to give way for progress, and our billboards sometimes are in the way, and we have protections in the Act that allow, if for a larger road or more lanes or new road constructions, that we receive just compensation. That's a federal statute which is ensconced within the state statute as well. So it was those three things that we said we won't grow anymore so long as we have these three things, which we have in statute. From 2006 on, we saw some minor changes here and there. Melissa Staufeld had mentioned some changes in 2014. That was around digital billboard permitting, probably something we should have done back in '06, but we came back in 2013 and finally got it done in 2014 and got those done along those lines. And so when you look at that, I think you heard from the department and you're hearing a little bit from me. We are a very highly regulated industry. A lot of folks, when I tell the story, they're like, huh? It's a sign. Well, again, we would argue that it's more than just a sign. But at the end, we have in the past accepted those level of regulations on our business. It's kind of those cases, show us where the hoops are, show us how big they are, and don't move them on us, and we'll be happy to jump through them because we know we've got a benefit on the backside. And we have seen over the years sort of I would say a waxing and waning of our relationship with the regulators and the Act. Sometimes we look at the Act and we see one thing and the department sees the same thing. And sometimes we see one thing and the department sees something else. And that does bring up some inconsistencies and irregularities in the Act. And it does put us in a situation where we find ourselves at conflict with the department at times. Whether that's over the vegetation permitting scheme or most recently and probably most important to this committee is in the area of condemnation and eminent domain and the potential cost that has to the state of Michigan, where that cost could be avoided through either some clarity in legislation or clarity in the budget, or perhaps even in a different view of the law itself as it is. So, and I want to use that as a bit of a segue to introduce Adam Barrett with Bodman PLC. That's right, it was shortened. Adam knows more about billboards than most of us. He is the foremost legal counsel when it deals with billboards in the state of Michigan and has been our legal counsel at the Outdoor Advertising Association for probably more years than I've been with the association. And I'm going to turn it over to him for a moment to kind of walk through the condemnation and eminent domain and the potential cost to the state of Michigan and the trunk line fund at a time when you all are looking at finding $3 billion in road funding to advance our highways into the future. And with that, I'm going to turn things over to Adam Barrett.
Good afternoon. Again, I'm Adam Barrett. I'm a partner at the law firm of Bodman PLC. I keep an office at Ford Field. I've been doing billboard work now for nearly 30 years. I'm a lot older than I look. And I can tell you that to Bill's point about waxing and waning, we are definitely back into a waning period of time between the department. My clients are large companies representing the vehicle for small engine growth. We've always viewed the department as a partner in trying to make sure that this advertising vehicle is available. It's the most cost affordable advertising that small businesses can find. However, we've had some recent run-ins with the department on a variety of issues. You've heard about the statutory scheme that billboards are unique, that they are regulated by federal law, state law, and also, you didn't hear from Ms. Staffel, but they're also regulated by local law. And she mentioned Lady Bird Johnson, and it's a funny story. Lady Bird drove with her friends, her girlfriends, to California and realized, she said, you need to do something about these signs. And so the industry has really developed around that. The state's ability to regulate billboards is controlled by federal law, but there are still some discretionary elements to it. And what we have found over the last few years is that the department is basically bringing over its discretion to be anti-sign. That's been a kind of a challenge for us. This issue has come up most recently in the context of eminent domain. There are a lot of shovel-ready projects moving forward. Most recently, we are doing an I-94 modernization in the city of Detroit, not too far from my office. That has resulted in approximately 20 assets of the billboard companies being subject to removal, and just compensation would require payment for that. The legislation, the just compensation regime is set up basically to come up with a way to pay the company for the value of the sign. The value of the sign is derived, typically when you value property, you use three approaches. You can use an income approach, you can use a market approach, meaning what would someone buy it for, or a cost approach. What does it cost to put this steel on the ground and depreciate the steel? The industry relies upon a 1960s Attorney General opinion to say you must do it under a cost approach, but no one can find that opinion. Other states have answered how to value a billboard. Obviously, the market has answered how you value a billboard. They're bought and sold all the time. But the department's position is that it's only worth its depreciated steel. So right now, I'm involved in 4 lawsuits with the department. The department does not use AGs for those. It hires private attorneys, hires those attorneys at a cost, and those attorneys litigate against me over how to value those boards, what's the proper mechanism for it. The issue that we've come up to, MDOT, and we have found no willingness to find solutions to it, is we as an industry aren't looking for just compensation. While obviously it's our property and we value our property, what we are looking for is solutions to either erect new signs within the permitting scheme of local, state, and federal law, or we're looking for abilities to find compromise on vegetation management. You heard about the vegetation management from Mr. Doyle. In part, I helped write that statute, and it's basically being weaponized at this point against the industry. The intent of that statute was to find a solution to give a certain amount of viewability to a sign, then you would pay, and if there was some type of remediation, such as new plantings and that and the like, they would ask you to do that. Now the department seeks upon us to do things like plant $90,000 worth of low-growing shrubs and the like, basically trying to supplant its responsibility to basically supplant the grand bargain of trading our right to seek the visibility of signs by making us obligated now to plant in there. The issue that I think that this committee is probably most focused on, though, is the just compensation piece. I am, in my case, have experts. Those experts have valued at least the 4 lawsuits I have that these signs are worth millions of dollars. I got notice that 3 more are coming down the pike 2 days ago. We have been very clear to that we are looking for relocation assistance from MDOT. MDOT has discretion. Now, it doesn't have discretion in terms of spacing. It doesn't have discretion in terms of zoning and the like. But it does have discretion on whether or not they believe that there is a blockage in the viewing cone. We can then come up with a shifted viewing cone. They do have discretion on whether or not a sign is, quote, visible to a regulated route. And visibility is an issue of great contention now with the department. The department believes that visible means you can see a sign, like I can see your Christmas lights from a distance. The industry standard on that is, can I read the message of the sign? That's what the statute says. And so we're looking for solutions with MDOT to say, we can employ technology, we can make the sign bigger, larger, but we're not looking for just compensation, we're looking for relocation assistance. And the department, for the most part, has been unwilling to find those solutions with us. And that's a problem. And it's a problem for not only for the billboard industry, but for those companies and small businesses that rely upon the availability of advertising. Now that you've been keyed into the billboards, when you're driving home today, look at those signs. See how they're promoting the local McDonald's and the local car dealer. Those are an economic engine that is unsurpassed in this state.
Is that it? We're done. Okay. So, being that we're in a budget, I'm curious on how much that the association is paying for these lawsuits, because I would think that if, and I'll ask MDOT, because they could probably answer for themselves, but the mirror image would be whatever you're paying, MDOT's paying, and that comes out of our road funding. So I would like to ask how much that you've spent, how many lawsuits, and where are we with those lawsuits, and are they only for the relocation or the just compensation of the cost value?
So, sure.
Income value.
A 30-second primer on a takings claim is the department goes out and makes an offer. And as you can imagine from my description, that offer is, hey, we'll give you $25,000 for this sign. Well, that sign might generate $100,000 of income a year, so that's not. We then reject that proposal, and they have to file a lawsuit. The lawsuit then allows the property immediately to go to MDOT's possession, so they can use it to move forward with that, and then we argue about the just compensation. Remember, in that type of an arrangement, although most litigants bear their own attorney's fees, under a just compensation type lawsuit of eminent domain, if I prevail, and my theory that the sign is worth more than the department is offering wins, the department, the state, me, pays my attorney's fees. So we're fighting over issues which I don't need to incur those fees. I certainly don't want the state to have to reimburse me for them, when all I'm looking for is an opportunity to build a new sign or move a sign or get some vegetation leeway for some trimmings. So how much in terms of costs? Those 4 lawsuits, right now, the department has moved to dismiss all of them, or basically say that they're right. Every judge, and this all happened in the last 2 months, has said, no, you're not right. There will be a jury trial on this. So we will now take the time of 8 individuals in Wayne County, times 4, 32 individuals, to have jury trials over the value of these structures and whether or not they agree with me that they are valued as the market would value them, or whether or not they are just the cost of their appreciated steel. So
How much so far? Can you?
in terms of my legal fees, I probably have gotten, I would say each case somewhere around $75,000. I would say the department is probably similar. Again, they're not using assistant attorney generals from Lansing or local regional offices. They're hiring private law firms to do this. So rather than come up with a solution to relocation, the department wants to fight with me, pay these attorneys, and possibly pay me on top of the risk of an award. I would gladly donate my fees to charity rather than to come up with something like this. It's utter insanity.
So $300,000, so I would be curious to see how much MDOT has paid for their cost on their end of legal fees. And you know what, unfortunately, I've been involved in a couple lawsuits. They take forever, they're very expensive, and nobody's happy at the very end. Everybody could be a lot happier sitting at a table trying to go through some of
And let me
these
add one
things.
thing, Representative Steele. They've also, we had 4 other condemnation actions that dealt with expired leases. Sometimes the industry does not get into an agreement with its lessor to put a new lease in place, and so the department buys that property, becomes our lessor, and kicked us off. They did pay us, they've already paid us just compensation to the tune of probably $300,000 for those assets that have been removed. So it's been a challenge. And if 20 more are coming, Representative Steele, I'm going to have, you might put $10 million to this, just in terms of compensation costs, plus attorney's fees, plus appellate fees. Because, without legislative clarity, some states have said you value signs one way, some have said you value it another way. Michigan has not answered that question in its statute.
Thank you. Representative Slaw?
So, question, I heard you say that there was some sort of federal rule that we're doing some of this stuff under that we can't find, first of all. Is that?
No, a state attorney's general opinion.
And so it's a state attorney's general opinion that was issued, but we can't find.
We can't find it, that's correct.
How do we know it was issued?
Because the eminent domain manual that the department uses when they go out to take any kind of property, be it your farm, your business, for the Gordie Howe Bridge, tells them the steps they need to take, and there's a section on signs, and it cites attorney general opinion. I've deposed the department multiple times, depositions where I ask questions of individuals,
Certainly.
and they've said, nope, can't locate it.
Okay. But in following up on that particular thing, did I hear you say that particular attorney's general opinion was that it should be done as a cost approach?
That's what I'm told.
Okay.
And that's what the manual reflects
For a
from.
value. Okay. Thank you.
Thank you. Representative Edwards?
Thank you, Madam Chair. I know this is a budget hearing, but I'm just curious to know, especially with the distracted driving stuff that we have going on, I'm just wondering if there's any information being collected or gathered that can say if Billboard is causing distracted driver accidents or not. We have that information?
Yeah, absolutely, Representative Edwards. I can actually get you a series of studies that were done a few years back by an organization by Tantella and Associates and Virginia Tech, one of the foremost institutes on transportation research, who did those distracted driver studies. And essentially, the Virginia Tech one is probably the most telling, where the Virginia Tech found your top items of distracted driving were your cell phone, your radio, kids in the car. Billboards didn't even rate within the top 10. So every study that's ever come out has shown definitively that billboards do not distract driving.
Thank you. Can you send me that report?
I will pull those reports and get them to your office.
Appreciate it.
Robinson? Hold. I just had a question about the marijuana signs. So do you have any, I know it's not regulated by the state, but there's a lot of free marijuana that I can pick up along the way, so curious about that.
Yeah, I'd actually like to, I would like to bring one of our board members, Denise Bartholomew up from Outfront Advertising, and she can kind of speak directly to the cannabis advertising.
Thank you. Oh, yep.
So this is just a follow-up on the question that Rep. Edwards had on the study thing. Were those studies done pre-digital?
They were done pre and post. Tantella and Associates has continued to do those studies for the Outdoor Advertising Association of America.
Okay.
So, and I can get you those copies as well.
Yeah, because that obviously digital change, the change thing might make a difference in how that was perceived. So thank you.
Good afternoon. Denise Bartholomew with Outfront Media. As Bill and Adam have mentioned, Outfront's been in the business since the 1800s. Our industry has continued to evolve with our signage and also what appears on it. To answer your question regarding cannabis, we've always had adult substances that we have been asked to display on our signs, mainly alcohol. So where our industry came in to self-police many, many years ago, we are also members of the Outdoor Advertising Association of America, who created a standard of best practices to adhere to for any adult substances, whether it be cannabis, whether it be alcohol, so on and so forth. So what we do as a self-policing organization, as members of that and as members of the Michigan Outdoor Advertising Association, we have separation distances of where we place those advertisements. We call them advertising sensitive properties. So churches, schools, playgrounds. We've always had a distance separation to space those advertisements from those types of properties that likely would not take kindly to those displays.
We also self-regulate content too, right? So
Correct.
we won't have on there messages that are promoting use or are confusing it with something that it's not. So we do a lot of that as well.
So does any of the representatives have any other questions for these testifiers today? And if not, I'm going to see if MDOT wants to come back up and maybe answer some of these questions that were posed. So thank you very much for coming in today. I appreciate it. And maybe even if you want to stay and see if anybody has other questions for you too. We're not going to be long, hopefully, I could stay here all day. It's other people don't want to.
So where do you want to start?
I guess if I were to start with my first question
Yeah.
is, how much money is being spent from MDOT on lawsuits? I mean, because maybe when we all leave, you guys stay in the room and fix this, and then both people could save a lot of money and time, and it would be a lot happier. Everybody would be a lot happier. But that's just, I'm a middle child, so that's what we do.
I am also a middle child. President Still, the thing about that is that we can get you those numbers, as relates to the lawsuits, the dollars associated with those. But of course, due to litigation reasons, we're really not able to go into detail or really talk about a lot of these lawsuits, as I think is referring to I-94 corridor down there in the city of Detroit area. But I think we can probably provide you some preliminary numbers as far as dollars spent thus far in regards to these lawsuits. I'm assuming you're referring to the specific 4 lawsuits that was mentioned.
And I know a lot of this is public record, so although you say it's confidential, I know that by the time you go to court and it's all testimony, it's all documented, and so it's public record, along with spending taxpayer dollars is documented as well for the lawsuit, so, okay.
I'll just add, 'cause the lawsuits are, the lawyers are handled out of the AG's office, so not, they work with MDOT, but the contracts that, were alluded to for the hiring of private, those contracts are done by the Attorney General's office, not MDOT. So that's why we don't have those numbers at our, disposal.
Rep. Robinson?
Yeah, so I just want to understand this. So the basis of these lawsuits has to do with not being able to create more billboards. Am I understanding that correctly?
No, and I'll let them give their side. The I-94 is, expanding, it's widening, so we are acquiring property, and within some of these properties were existing billboards. So like they mentioned, we're buying the property, and then we're also acquiring the billboard and the lease as part of that acquisition, so.
But I think I heard you earlier talk about that there hasn't been any more billboards added.
No, as they both explained, they were capped at the number.
Refresh my memory, why were they capped, please?
I think Bill kind of eloquently stated that they were willing to work on other compromises, and I'm not want to put words in his mouth, but what he had said was that they were willing to provide a cap on billboards in consideration to other things as part of the changes and amendments to the statute over the years.
All right.
Rep. Edwards?
I just have an environment question.
Yeah.
Sorry. But how much does the billboards contribute to light pollution or any other environment issues?
Yeah, I mean, that's
Yeah.
the big thing. When we evaluate for tree removal within our right-of-way, that's a huge consideration. And that's why we require, an arborist, and that's why we have a really detailed process for review with our resource specialists. Because, the vegetation, some people just say, well, it's just a tree, but it provides so many different, aesthetics. It helps with soil erosion, with our drainage. It actually provides a natural snow barrier for blowing snow. So there's so many other benefits to the vegetation. So yeah, it's a huge part for us for those trees. And I mentioned earlier that we utilize federal funding for planting of new vegetation, whether it be trees or grass, anything to help with erosion and other things for the property that we maintain. Yeah.
Just earlier, it was mentioned about the eminent domain process,
Yeah.
and that there's an eminent domain manual from the previous group. And so I was curious about that manual, and has it been reviewed at all, or is it, I mean, because when you think about people's rights,
Yes.
and you think about government overstep,
Yes.
eminent domain is a very touchy topic.
Absolutely.
And when they had mentioned the fact of that when we expand these roads and then the MDOT buys the property and gets rid of the signs, I mean, that's kind of like a maybe overreach. So I'm curious about this manual. And then I was curious also about the Attorney General's opinion about this, because I'm sure that's why the Attorney General has been called in with these lawsuits, that they can give us a better oversight internally to make a decision to be able to move forward. So those two items.
Well, in regards to the AG opinion, again, we'll have to defer to our AG on regards to that. I think it was alluded to that is not available as far as that opinion goes.
Is it done yet?
This was a
Yeah.
prior opinion. I
Yeah.
think that,
Probably.
that, you know, it is accurate that they were not able to find that previous opinion. But I will add that we work with the AG's office on every case. You know, our goal is to not have to go to utilize eminent domain. We try to find, you know, a settlement with property owners. Eminent domain or condemnation is a last resort. And anytime we do that, we bring in the Attorney General's office to assist with those proceedings. You know, as far as the previous AG's opinion, the current staff that we're working at the Michigan level of the AG is the one that is advising us, saying that our approach to evaluation is correct. So while we don't have that previous AG opinion, we're going under the guidance that we have now that's saying our approach is correct based on their review of other states, the statute, and then thus the disagreement. So-
Well, being in real estate before, you want the rebuild cost in a bad market, but you want the market value in a good market. So I would think that the billboards would want that same type of, that you could go one to the other based on what market's in, and that both of them should be looked at. So, do
Yeah.
you have a?
Yeah, I just want to ask, I appreciate the opinions of these judges, but I think this is way too much overreach, and I find it kind of ridiculous that this is where we're at.
Any other comments from?
No,
MDOT?
just to say, you know.
Thank you for coming here, is
yeah,
what I'd
you're
like to
welcome.
say,
Yeah,
but
you're
go
welcome.
ahead, say one other.
No, I was just
cut
going to
you off.
say, you know, it is, the statute is very complicated. You know, the billboard regulations is one side. Condemnation is completely, to get to your point, we do have a real estate procedure manual. I can provide that. It also talks about condemnation. But we have very strict, both at the federal and state level, for condemnations because of things that have happened in the past that have been rectified, that there is very strict requirements for condemnation and the paying of just compensation.
Hence is the reason why we always have our AG with us whenever we're
Yes.
dealing with condemnation.
Yes.
Okay, I'm going to defer to you maybe after the meeting, if that's okay. So, I don't want to go back and forth, but I would, being that it's a service industry, I look at this as a service industry. They're getting permits from you, they're getting vegetation permits, they're paying a fee, that I would think that we could be more collaborative and sit at the table instead of putting manuals and going to court with a judge for these courts. I really hope that this would be maybe something that we could work through instead of spending time and money on this, because small businesses are the engine of the state of Michigan, and this is a business for these people. And I know in our town, they do post up there, congratulations, Billy, for winning the baseball game last week. So, I mean, they're a big part of our community, and we need to recognize that. So,
Thank you very much, Representative Still.
yeah,
Appreciate that.
so thanks. And with that, with no further business, we're adjourned.